I'm Sue O'Connell. Tonight on Greater Boston, Fox News will now pay hundreds of millions of dollars to settle the defamation suit brought on against them by Dominion Voting over 2020 election lies spread on air. We'll dig into what this means for the media landscape. Then, a forthcoming book calls out the statewide failures that ultimately led to the disappearance and assumed murder of 5-year-old Harmony Montgomery. I'm joined by the author of that book, along with the couple who adopted Harmony's half-brother. The courtroom was packed, the cameras were ready, but the trial was called off at the last minute when Fox News agreed to pay Dominion Voting Systems nearly $788 million to settle the 2021 defamation suit the company brought against the network. Now, the suit, as you well know by now, revolves around Fox's promotion and peddling of misinformation about the voting systems on air and online, including baseless and categorically untrue claims the company's machines were rigged to steal the 2020 presidential election. Now, as part of the settlement, Fox put out a statement read by Fox Media Buzz host Howard Kurtz. In one of the very few mentions of the case on Fox's air, in it, the network makes this concession.
We acknowledge the court's rulings finding certain claims about Dominion to be false.
What you're not hearing there is them admitting to knowingly promoting lies about Dominion or issuing any kind of apology of any kind. The more than $750 million settlement is the largest of its kind. But what, if anything, does it bode for Fox's future, for the media industry as a whole, all of that? Well, to discuss all of this, I'm joined by Elahe Izadi, media reporter and co-host of Post Reports, who I listen to every single day on the Washington Post. Welcome. And Daniel Rauch, lecturer on law at Harvard. He focuses on technology, democracy, and First Amendment law. Busy day for you two. There's no doubt about that. Let's start with you, Elahe. What was your reaction when you heard that there was not going to be a trial, that there was going to be a settlement?
Well, first of all, I was kind of overseeing some of our live coverage, so I was off to the races. But I have to tell you, we knew all along that technically the two parties could reach a settlement at any point during the trial. We were expecting the jury to have been selected and opening statements to have begun on Monday. That was delayed by a day. We got indication that that was to allow both parties to maybe reach a last-minute settlement. Our reporting at the time didn't indicate that they were anywhere near that. And so all of us were anticipating that, after the jury was selected on Tuesday, they went to lunch and opening statements 1 hour later. And as that delay went on, this really represents a stunning conclusion to a 2-year-long legal battle.
Yeah, Daniel, it's always... I don't want to say this out loud, but there's a part of me who's like, who am I supposed to be rooting for here from a media standpoint? Obviously, Fox lied. They did terrible things. The line between, I'm an opinion commentator. If I come up with an opinion based on what I think the facts are and I'm wrong, does that make me open to a lawsuit? Not obviously of this size. But what was the First Amendment part of this that made it a little bit more complicated than just to say, liars, you're wrong?
Well, first of all, Sue, thank you so much for having me on this evening. It's wonderful to be here, and I feel like defamation law is having its moment in the sun. And what it comes down to is a very famous, very prominent Supreme Court case, which was New York Times v. Sullivan. Came out at the height of the civil rights movement and was seen as a major victory for free speech. And it set very, very high bars and hurdles for any defamation plaintiff to surmount before they can successfully sue the press. They have to essentially show not only that there was a false opinion or a mean opinion or even a lie or even a negligent lie, they need to show actual malice. And I think we saw an attempt to make this proof in some of the really jaw-dropping discovery that we saw throughout this case.
Yeah, Elahe, I got to tell you, I have a lot of friends in the law world who say to me, don't ever text anything. Like, what do not text anything, do not...
They're smart.
Do not DM anything. If you're going to have a conversation about something, have a conversation. I have coworkers who, will not say anything unless they make sure phones are on, like, the other side of the room. And I'm now understanding that. But, this recklessness that Fox engaged in on the air And then behind the scenes, I mean, I'm surprised they didn't end up that Dominion didn't end up with more money.
Well, as we saw through the discovery process, I mean, this is really why, like, a lot of media companies don't even want to go to trial. It's rare for a defamation lawsuit against a media company to get to trial, which it technically did in this case. And part of the reason, in addition to, what was wonderfully explained, is this high standard and high legal bar that plaintiffs have to surpass when suing, that discovery happens, that precisely all these internal communications, text messages, emails, they could become part of the public record. And in this case, a trove of internal documentation from Fox News was made public. And now we, the public, get this unprecedented view into the inner workings of a very powerful media company that's also quite a force within Republican politics as well. And so I don't know what the content of your emails and text messages are, but in this case, some of the things that we saw were hosts like Tucker Carlson, who is hugely popular, gets lots of big ratings, saying privately that he thought Sidney Powell, this attorney aligned with Trump, that she was lying. He also said things about Donald Trump, saying he hates him, and provided us a sense of what did people privately say, even though they were defending the president in public on their programs. I mean, really, that's why this case was so closely watched, not just for the defamation claim that was going to be hammered out in the courtroom, but also for some of these ancillary reasons as well.
Daniel, as Elahe says, rarely do these cases go to trial because either the insurance company that is got the libel insurance for the publication or for the media company wants to settle, or they've got deep pockets and they don't want people to know their business. But had this gone to trial, could it have changed? And has it changed, even though it's a settlement? Has it changed the way people view libel and slander lawsuits and the First Amendment when it comes to media?
Yeah, it's a wonderful question. I think that the question to ask in some sense is not just what this lawsuit has done to change and what trial would have done, which I think would have been quite dramatic. I think you would have seen Tucker Carlson and Rupert Murdoch taking the stand under oath. I always say courtrooms are where conspiracy theories go to die. Everyone's sworn in. So it would have been a very dramatic moment. But if you look at the broader trend toward defamation suits, I think that has real potential to change the media landscape. I know that Elahe reported, I think just today, about the Smartmatic suit and how there's a whole slew of similar lawsuits, certainly from Wandrea Moss, the Georgia elections worker who was slandered and has gone after many of these similar defamers. And so I think combined, those lawsuits have great potential to change the media landscape.
And Elahe, as Daniel's mentioning the Smartmatic case, that's next on the dock for Fox News. That's a second major defamation lawsuit. What's that lawsuit about?
Yeah, so that claim, which was also a lawsuit filed in 2021 around the same time within a span of months as the Dominion lawsuit, that was a $2.7 billion lawsuit. Smartmatic is claiming that as its damages. That case, a judge in New York in February allowed it to proceed. We're still quite a ways away from a trial. Fox spokesperson told us that it would be 2025 is when they're eyeing this. I think, and it also, just if you look at what they're claiming, it's similar sort of things as what was said about Dominion was also said on air about Smartmatic. Now, they're two different companies, and so the financials of these two different companies will become a relevant component of this. I have to say, Fox's defense, especially in the days leading up to the trial, they were very aggressive in saying the Dominion claim of $1.6 billion was overinflated. And so I will imagine that that's also going to play a part. But if I could, on the First Amendment piece, what's so fascinating about this particular case, the Dominion case, was that the judge had already ruled in a pretrial hearing that Fox's lawyers could not argue that the First Amendment was a defense for libelous speech. And so even though Fox, in the lead up to the trial, kept arguing that it was a First Amendment case and that the underlying principles of actual malice have to do with First Amendment, in the courtroom, they were very limited in what they could have argued. I don't know what's going to take place with the Smartmatic case, but we're already receiving indication that they're saying that this is an attempt to chill free speech.
Yeah, and Daniel, I mean, I know you want to build off that, but, I always thought Fox would have been better off just saying it's entertainment, it's satire, it's not even news. I mean, what's their next defense going to be on this? I imagine they're going to be in the same position.
Yeah, it may play out in a quite similar way. And one, I think there's almost a consensus evolving that this might be the least satisfying $800 million payout in American history. I think if you look at the catharsis that people hoped to come from this, it didn't. And part of why it didn't is I think that for Fox, which had a $4 billion cash surplus on hand, according to the latest information, this might become cost of doing business. And so you might see them cut a similarly very large check in Smartmatic, and you may not see dramatic change there either.
Elahe, it's amazing to me that there doesn't seem to be on air on Fox. You know, I think we showed the only point that it was made. I mean, I when I'm at work at my other job, we have screens everywhere, and I don't ever see them talking about it. I mean, are they just going to continue to live in this world where this major news story, which impacts all media, just didn't happen?
Well, it's interesting you bring that up. Actually, a few hours ago, I just published a piece sort of reviewing some of how the coverage on Fox itself of the Dominion case. You did air a little bit of it. I found a handful of instances in which the case was mentioned. The broad contours of it were described. Only one instance I found in which the actual settlement amount was said on air. It was said on air once and attributed to the Wall Street Journal. By and large, this story has dominated all of its competitors on television and across newspaper. I mean, it was on the front page of almost every major newspaper in the country today. And it was mentioned here and there on Fox, but that's the big question on my mind. Like, Fox's most loyal viewers, are they aware that this case even existed, or some of the deeper concepts related to it? Are they aware that the judge ruled from the beginning, 2-3 weeks ago, that they couldn't argue in court that there was any veracity, any possibility of veracity to these election fraud claims? And more importantly, as you mentioned, there's no apology. There's no retraction on air. That was not part of the terms of the settlement, according to two sources close to the network who spoke to a colleague of mine. And so will their viewers know the truth of the matter, which is that the election was not stolen and that Dominion voting machines had nothing to do with any such thing?
What's the lesson here? What's your lesson plan when you're teaching this case? What's the takeaway?
I think the takeaway is stay tuned, and I think the big takeaway might come in 2 or 3 years, depending on what the Supreme Court ultimately does with New York Times v. Sullivan. I think there's a real sense that a lot of the rules that worked in the time of Walter Cronkite don't work as well in the time of Pizzagate and Stop the Steal. And so my lesson plan may shift very dramatically in the next 2 or 3 years, I think.
You know, what makes my head explode about this, Elahe, as we wrap up here, is that I'm always arguing that in the media, when we make a mistake, we have to put a retraction. We have to say we made the mistake. Like, there's all sorts of people. Plumbers make mistakes all the time, and they don't have to say that they made a mistake. And that we're basically doing our best to tell the truth. And then this happens, which we knew they were doing. And but the people who are watching Fox don't seem to know that their suspicions about the rest of us are right under their nose. They were being lied to.
Well, and it also just sort of speaks to the media bubbles that so many people operate in. Like, the days of Walter Cronkite are gone in many ways, and that's one of them. A lot of people consume their news from outlets that are already aligned with their worldview and providing a particular skewed perspective. And so if we're not all consuming the same sort of facts and information, then that's an issue for our entire democracy, not just for media law.
Well, we'll leave it there. I appreciate both of you, Elahe Izadi and Daniel Rauch. Thank you so much for joining me. Appreciate your expertise and talking about this. We'll rejoin for the next one, okay? The next lawsuit.
Yeah. Thank you.
Sounds like a plan. Thank you.
After 5-year-old Harmony Montgomery went missing in 2019, questions began to swirl about whether the state failed to act on warning signs that would have kept her safe. Now, Harmony is presumed dead, and her father, Adam Montgomery, is charged with her murder. And a new report from the state's Office of the Child Advocate reports that the state is still not adequately protecting children in custody cases here in Massachusetts. In Harmony's case, her father was granted sole custody despite a history of violence and abuse, and she remained in his care even after the Department of Children and Families were told she was hit by her father and later saw signs of a fading bruise on her face. In the months after her disappearance, the child advocate reviewed her case and made several recommendations on how the state should handle future cases. And in its latest report, the Office of the Child Advocate says it continues to be concerned that the welfare and best interests of the child is not adequately presented in care and protection cases, putting some children in unsafe situations. I'm joined now by the retired justice on the Worcester Juvenile Court, Carol Erskine, who's writing a book on this case and oversaw the adoption of Harmony's half-brother Jameson just weeks before the authorities believe Harmony was killed, plus Johnathon and Blair Miller, the couple who adopted Jameson and have since been fighting to prevent what happened to Harmony from happening to anyone else. Welcome to all of you. Thank you for joining us. Johnathon and Blair, I want to start with you and just ask if you can share with us any memories that your son has about his sister.
He does. He definitely has memories about her. He will ask about her often. He remembers what her favorite colors were, purple and pink. He knew that she loved Minnie Mouse. Matter of fact, Blair's mom, who our boys know as Nana, made pillows, and she made one as Mickey Mouse and then one for Minnie Mouse. And he said, I'm going to keep that for my sister Harmony. It's a really hard thing to share with him, that's not a reality, that he's never going to be able to give that to her. He remembers that when they were in foster care, she had a Tickle Me Elmo that he really wanted, and she gave that to him as a gift because he didn't have any toys at one of the foster homes they were at.
Carol, what an extreme example here of the way that two children's lives could possibly go. One ending up in a loving household with the care of parents who are putting his best interest forward, and obviously the government's role in helping that to happen, and then the other child murdered. Is this how it always has been, and is this always how it has to be?
Well, I think the child legal advocacy system has been defective for a very long time. And that's why the Office of the Child Advocate made the determination that the Committee for Public Counsel Services, which has the unit that represents children and parents, is a defective system. And that basically what I write about in the book is that you had 3 attorneys on that case, as the governor said, and not one of them had Harmony's best interest as a priority. But the system is really a damaged system in Massachusetts when you have the lawyer for the mother, the lawyer for the father, and the lawyer for the child all in the same courtroom. They're all hired by the same people. They're all paid by the same people. And so the point I make in one aspect of the book is that it's a parent-focused agency to the exclusion of a child's best interest. And so my prediction is that there will be more child fatalities because the Committee for Public Counsel Services says that it doesn't have to change its particular way of representing children, meaning that they allowed Harmony at age 4 to decide what her future would be.
Carol, I've had conversations with people who work, both law enforcement and people who work for social agencies dealing with families in distress. And they have often shared with me how, as much as they want to protect the children, they often feel that when taking a child away from a parent, removing a child from a home, to them is a line crossing that they feel sometimes the government has to be absolutely sure that they're moving forward with the right information, and sometimes they don't feel that they have that. Is this failure through the entire system? I mean, is it both the social workers on the ground, and not as individuals, but as a system? Are we just totally over the line here?
Yes, it's a systemic issue throughout Massachusetts. I mean, the department's underfunded. Social workers literally put their lives on the line. I mean, the line social workers are amazing. They walk into some of the most dangerous situations. And, you have a group of people who say, foster care is not always needed and the department acts too quickly. And sometimes that's true. But that's for a judge to decide at the initial temporary hearing. And there are many times where I would say, I don't think we need to remove this child. Let's get some services in, let's have a safety plan, and let's return the child. But there are other cases where, the evidence is overwhelming that the child is at risk and needs to be in a safe place, despite the fact that, as we know, foster care can be really traumatic for children.
Jonathan and Blair, I'll let you choose which one should answer. But what is motivating you here? What do you see that you can impact in a positive way to make change to protect children?
Well, I think that, we sit here a year and a half nearly since we found out that Harmony was missing. And while there's been plenty of outrage and concern, and the community has played a vital role in all of this and support and in the search, but here we are. And I would ask, how much has changed since then? If there was another Harmony Montgomery case that happened today that went through the courts, what would happen? And why hasn't enough changed to make sure this doesn't happen again? And those are some of our biggest questions, and that's our motivation now. Sure, we're very concerned about, Jameson and how he grows up thinking about this, but everything we're doing is in Jameson's name and Harmony's honor.
So, Carol, I imagine in your book you're outlining this for us. But as I was preparing for this segment, we're talking. People get confused about which child in danger, which child who was murdered we're talking about, which speaks volumes as to how horrendous this problem is for the state to have, especially a state like Massachusetts, which prides itself in being good at many things. What steps does the state immediately have to take? And I know that it's in the report, but what would you urge lawmakers and people to do to take immediate steps to keep children safe?
Yes, it's a great question. One of the things I write about is the efforts that we made with Senator Moore to put a working commission together to take a look at the antiquated law and legal advocacy system in Massachusetts. And it was voted on unanimously and then went to the conference committee, and it was just crushed there. And so I write about the fact that, you have the judiciary, you have the executive branch, and you have the legislative branch, all of them not doing enough to make the changes. And one of the immediate changes, in my view, and this is in the OCA report, but I explain it, to a much greater degree, is you cannot have 4-year-old children deciding their future. It's dangerous. It's not done like that in most other states, which have a best interest model along with express preference. But the Committee for Public Counsel Services is fighting that all the way in Massachusetts, and I spend a lot of time, talking about how it's such an indignity to Harmony for people to ignore this really defective system that's in place.
Jonathan, I imagine the grief that your household feels over Harmony's murder, both in opportunities missed and also just the family care and just as human beings. How do you as a family deal with processing this grief and trying to turn it into action?
Well, I think, number one, we can't change what's happened to Harmony. If we could go back, we would do anything to make that happen. We're not able to change that, sadly. But we can tell Jameson that he's loved. It is very difficult to answer his questions. He looks at us and says, "Why did my sister have to die? Why did someone have to hurt my sister?" He doesn't realize that her own father hurt her. That's just too hard for a 6-year-old to even comprehend or understand. Is what we can do is love him unconditionally, get him the services that he needs. And we can fight to make sure this never happens again to another child. But it is, and it could happen again, like right today. For instance, a few months ago, our doorbell rang. And even after Jameson knew the tragic ending to Harmony, he said, "I hope that's my sister at the door." That was his only stable person in his life until he was adopted.
It's heartbreaking and it's unnecessary. Blair, folks, I get frustrated in this business covering terrible stories like this where there's an enormous reaction of love and concern and heartbreak, and then we just kind of move on. right? And then the next time it happens with the same circumstances, we're all shocked it happened again. What would you say to folks watching at home, a step that they can take this week to try and stop this from happening again?
You know, I say the same thing. You know, look, I get it. There's a lot going on in this world. Everyone's very busy and everyone's trying to sort out life for themselves. And when things like this, yes, there's a lot of outrage. I think some of the same questions we're asking to our lawmakers is, what are you doing about this? And why hasn't this changed? What is your role in making sure that we're keeping all of our kids safe?
Carol, is there a state that's doing it right? Is there somebody who would be a model for us, or at least moving in the right direction, doing it at least trying to do it the right way?
Yeah, there are a number of states, in my view, that do it right. Actually, Massachusetts is only one of 8 states that allows a singular express preference model, allowing children to make decisions that could put them at extreme risk. But there are 32 states in the United States that have, even if they have an express preference model, that there's a guardian ad litem or an independent voice to speak for those children, so that you're not just getting one story. In Harmony's case, the lawyers all agreed that they weren't going to present, they didn't present any evidence to the judge about his criminal record, about the fact that he didn't do any services 6 months before the custody order went in. And so it's a difficult situation, you know, when you're a judge and you're relying on evidence and the evidence isn't coming in. So I think, you know, that Massachusetts should move to a similar model that is in the majority of states, where a child's voice gets to be heard separate from the lawyer.
Well, I appreciate the 3 of you taking time to share this concern and call to action with us. Carol Erskine, Johnathon, and Blair Miller, thank you so much. I appreciate your time and expertise. Thank you.
Thanks for having us.
That's it for tonight, but come back tomorrow. Boston City Councilor Ruth Z. Louis-June joins on her support for the physicians, interns, and fellows at the Mass General Brigham, who are fighting to form a union alongside one of the resident physicians at the hospital leading the charge. That and more tomorrow at 7. Thanks for watching. Good night.
This is the most